We get a lot of questions from California lawyers about a case known as Dynamex. What does Dynamex mean in terms of the law clerk model? Let's break it down. Dynamex is a California case from 2018. Some attorneys interpret it to mean that they can no longer hire freelance lawyers. This is a misinterpretation, and here's why. The Dynamex case involved two workers suing on behalf of a class and challenging their classification as independent contractors. The individuals worked as same-day couriers for Dynamex, a nationwide same-day delivery service. The lawsuit hinged upon the fact that prior to 2004, Dynamex treated its couriers as employees. After 2004, they were reclassified as independent contractors, yet still performed the same functions as when they were employees. Pretty much the only things that changed was a significant decline in compensation and benefits. It was up to the court to decide whether the workers should be classified as employees or independent contractors for purposes of California wage orders. Wage orders impose obligations relating to the minimum wage, maximum hours, and a limited number of very basic working conditions for California employees. In Dynamex, the court held that the workers were misclassified as independent contractors and they should be classified as employees and thus subject to California wage order laws. Further, the Dynamex court established a new ABC test to determine if a worker is an employee or an independent contractor. The ABC test presumes that all workers are employees. The fear among those in industries dependent upon or thriving because of freelance workers was that Dynamex would replace the common law test set forth in the Borello case from 1989. In the subsequent cases since Dynamex, this fear has not come to fruition. Universally, state and federal courts have held that Dynamex is extraordinarily limited in scope, and it did not replace the Borello standard in every instance, where a worker must be classified as either an independent contractor or an employee for purposes of enforcing California's labor protections. So what does Dynamex mean from a practical standpoint in terms of law clerk? Dynamex has had very little impact upon industries much more closely related to the courier industry and the gig economy. Uber and Lyft still exist and are thriving in California and nationwide. Their drivers remain classified as independent contractors. Is there a risk to attorneys hiring freelance law clerks in California? Technically, as a lawyer, of course, I'm going to have to say the answer is yes, but the risk is really small. California wage orders aim to provide only subsistence-level wages and basic benefits for employees in California. In our experience, the freelance lawyers on LawClerk are earning far beyond minimum wage, so a suit over a wage order violation is quite unlikely. But if you're a California lawyer and you're still worried about Dynamex, one easy solution would be for you to only hire freelance lawyers from states other than California. The LawClerk model allows hiring attorneys to hire freelance lawyers to do work in a paraprofessional capacity under the hiring attorney's direct supervision. Thus, it is easy to find and connect with freelance lawyers from other locations. We have two great blogs on our site, lawclerk.legal, which discuss all of these issues pertaining to Dynamex in much more detail. So I invite you to visit lawclerk.legal today to read those blogs and learn more.